We now turn to looking at the final material for Part 3, namely causation in the law. Now the first focuses on the notion of harm. In law, causation is typically the connection between the action and harm. As a general rule, only if your action causes harm or contributes to its cause can you be said to be responsible for that harm. In civil law, it's a necessary condition of tort liability that a person's actions cause the harm in question. It is also a necessary condition for some, but not all kinds, of criminal liability. Now, since this is law, as one might imagine, there is some Latin in there, and the key concept here is this. It's conditio sine qua non, or translated in English, a condition without which nothing. It's sometimes referred more properly as the but-for causes. That is to say, Y would not have happened but for X's having happened. For example, if the food had not been contaminated, then Sally would not have gotten sick. Or if the stepladder was not defective, then Bill would not have fallen and broken his leg. Now, in terms of punishing people, in general it would be silly and morally wrong to punish a person for causing harm Y by doing X when Y would have happened without X. So, to punish someone for doing something when the effect would have occurred anyways, in general, there can be obviously some exceptions, but generally be silly. Now, of course, the sense of cause, that without this there would have been no effect, can go on indefinitely. For example, if we look at the World War II, well, if Hitler's parents had never met, perhaps World War II would not have happened. And perhaps if, Hitler's great-great-great-great-great-great-great-grandparents, World War II wouldn't have happened. However, we probably wouldn't want to assign moral responsibility to Hitler's great-great-great-great-great-grandparents for World War II. So as you might imagine, when we're trying to sort out, legal cause, what we try to do is obviously we don't just say, well, some causal connection. We look for proximate cause. This requires putting some severe restrictions on the notion of sine qua non. Because obviously there are many things that would not have happened without something, but we generally would not want to assign, say, moral or legal responsibility based on those. And to use the opposite example, someone who commits a terrible murder, they would not be able to do that except for their great-grandparents. But you would not go and, say, arrest the great-grandparents because, for what the great-great-grandson did, if there was no other connection. Now, in the case of law, a sine qua non cause is a matter of fact. A legal proximate cause is a combination of fact and decision or policy. And so we talk about the legal cause, it's not necessarily what we consider, say, scientific cause, but a different matter. It involves the laws that govern these things. So deciding what is important or significant requires a decision or policy. What's considered sort of the standard article on the matter was written by Hart and Honor, wrote an essay about causation in the law. And they tried to show that common sense can guide the necessary decisions. They argued that to hold a person legally responsible for harm, we've got to be able to trace that harm back to the person's actions. For example, if there's a massive fire in California, and they're able to determine that someone was at a campfire that started it, well, it would seem reasonable in that case to hold them legally responsible for that fire. Now, there are some features or factors that are regarded as intervening forces that could mitigate responsibility, and others that would not be. For example, if were very, very dry conditions and the cigarette was fanned by the wind, well, that doesn't really mitigate the person's responsibility. The fact the brush was burnable and the wind, was present are not things that would make the person legally not responsible. But if it was shown that the person had put the fire out properly, and then someone came along and brushed away the sand they put on it and threw gas on it, that would obviously mitigate responsibility because someone else had a role. Because if the fire had not been uncovered and gas thrown on it, then obviously the person would not, the fire would probably not have occurred. In some cases, coincidence intervenes and mitigates. For example, suppose Sally punches Sam, and he runs away, and then a tree falls on him and kills him. Although Sally, could be held accountable for punching him, assault, the fact that the tree fell on him and killed him, Sally would probably not be held accountable for that. Now, a lawyer, of course, could argue that, but it would seem that, that she did not, unless she actually lured him into that trap, and punched him to drive him into the tree, it was just coincidence. Then, even though she could be, again, held accountable for assault, clearly not for murder. And that brings us to the end of our brief discussion of causation in the law.